Next policy is 3122, non-discrimination and equal employment opportunity. Again, these revisions have been brought forth based on the reviews we have gotten from other clients who have experienced investigations and audits from the U.S. Department of Labor, EEOC, and OCR. So we've given you the definitions that they've said they're looking for, the identification of a compliance officer, the inclusion of complaint procedure or a reference to that complaint procedure, again, so it is easy to find, and then also the reference dealing with retaliation.
Board members, comments, questions? If not, we'll move on to the next. Oh, no. Go ahead.
Sorry.
Sure.
If we could please address some of the legal questions that were brought up, and I had the same questions because we do refer to legally protected classifications when we're talking about the complaint procedures. If that does not align with the listing above, I think that needs to be clarified. So talking about line 29, which refers to legally protected classifications.
And what would you like to see?
I'm asking a legal question versus in line 8 where we did add the language or is proposed the sexual orientation transgender. If that is not included in this legally protected classification below, is there some clarification that's needed?
Sure. I mean, that's a fair question. Transgender, for example, is not as a term present in Title VII or in Title IX. Nevertheless, there is extensive, in this case, because it's an employment situation, you're dealing with Title VII. Nevertheless, there is now a very extensive federal case law in which there is protection for transgender status as a sex issue. There was a case called Glenn v. Brumby in the 11th Circuit that was issued at the very end of 2011. And so it may be a good idea, Mr. Donalds, that I read a couple of sections so you see how the court reasons these things through, because it usually looks at it, A, as discriminatory. So somebody is fired because he or she is transgender and the employer said, don't want you here. Or it goes back to what's known as sexual stereotyping. The concept of sexual stereotyping actually goes back to a Supreme Court case in the early 90s in which a woman had tried to become a partner at a large accounting firm. And they said to her, well, she's got a great book of business, but she just doesn't dress or act feminine enough. Well, this is Price Waterhouse. Price Waterhouse versus Hopkins. Supreme Court tagged Price Waterhouse and said sexual stereotyping, in which one perceives how someone should behave in accordance with a gender, is not what you look at, and accorded her protection. So they've taken all of these concepts and they've brought them current. And that applies to harassment, and that's why we brought it into the other policies. So you can get a sense of it. Let me just read some of the opinions, because the person in this case was a governmental employee. We're the government. So this would be a case that would apply to an employee, hypothetically here, that might be let go on the basis of transgender status. And the person filed under equal protection, the constitutional equal protection, and filed under sexual stereotyping and sex discrimination. And this person, the court found for this person on all counts. So it affirmed the trial court. And this now is the law of the 11th Circuit. That's why I don't wish to be critical of other comments, and I understand where people are coming from, but the violation of law will come when you attempt something like that and turn to the court and say, well, this really is not within a Title VII protected classification, and the federal judge will say, no kidding. So if we look at this as sex or gender, that wouldn't qualify, and you're dead in the water at that point. So the category itself of sex or gender doesn't need to include in Title VII or Title IX a specific name, but the courts are now identifying them very clearly and protecting them. So let me just read some of this in this particular case. A person is defined as transgender precisely because of the perception that his or her behavior, and we heard the comments about behavior, transgresses gender stereotypes. The very acts that define transgender people as transgender are those that contradict stereotypes of gender-appropriate appearance and behavior. Accordingly, discrimination against the transgender individual because of her gender nonconformity is sex discrimination, whether it's described as being on the basis of sex or gender. Indeed, several circuits have so held. This 11th Circuit relying upon a whole series of federal circuits. All persons, whether transgender or not, are protected from discrimination on the basis of gender stereotype. For example, courts have held that plaintiffs cannot be discriminated against for wearing jewelry that was considered too effeminate, carrying a serving tray too gracefully, or taking too active a role in child rearing. An individual cannot be punished because of his or her perceived gender nonconformity. Therefore, we conclude that a government agent violates the Equal Protection Clause prohibition of sex-based discrimination when he or she fires a transgender or transsexual employee because of his or her gender nonconformity. So
am I correct to say then that they're referring to the sex legally protected classification of
well, transgender
sex?
Would be brought into that. So the purpose here was just to make clear what's already present in the law.
So should we add religion, in parentheses, Christians, Muslims? I mean, should we clarify all these other statements as well?
We have religion in there. And here's an interesting thing that...
without the clarifying statements, though.
Well, here's the interesting thing there. Title IX, for example, well, not Title IX by itself, but OCR, you often wonder, what do they enforce? Well, they enforce several statutes. They enforce Title VI, which no discrimination on the basis of race, color, national origin. Title IX, no discrimination on the basis of sex or gender. Title II and Section 504, no discrimination on the basis of disability. Now, what's missing there? You say, well, where's religion? It's not there. Nevertheless, OCR has issued letter rulings that if any district discriminates against somebody on the basis of religion and OCR gets a complaint, they will fully investigate it. In other words, they're looking to what is harassing, what is alienating conduct, what's discriminatory conduct, and will sweep in other classifications and protect them, even though they might not be specifically identified in the statute. And for that reason, we felt we would add in those two other categories. In fact, in one of our policy, sexual orientation is actually in there. But transgender now has become such a litigated issue that when Mr. Corbett brought that to my attention, my reaction was that actually is the state of federal law as I understand it now. So there's no effort to try to bypass who's protected, who's not. But the reality is persons, however you want to classify them, if they are harassed, whether it be employees or students or are demeaned, our policy ought to have a way to give them protection. This does not mean that the district is condoning sexual behavior any more than by putting religion in there, you're condoning a particular religion. We even put in there, Mrs. Donald, you've probably seen in many of our policies, political affiliation. That's not in Title VII. That's not in Title IX. But we wanted to make sure that people had certain basic First Amendment rights to speak out on political issues. And if somebody went after them, we're going to make sure that you will be held accountable.
Well, and I don't think anyone on this board would want or advocate for discrimination for any reason for any of these listed. My concern, which has been expressed by some here and several outside of here, is adding unnecessary clarifying statements when, just as you explained, the law actually protects them under the category of
So
sex.
could I just interject
Yeah,
for
sure.
a moment?
I think it's a good
I'd like
debate
to
to
hear
have.
from some other board
Sure.
members.
And my original question was whether it needed to be clarified the legally protected classification under the complaint procedures when we are listing above those that are not legally protected, as you just indicated, beyond sexual orientation, but also others.
What you could do, since, of course, as you understand, you make policy here. So you're entitled to create protections for people. You're not violating the law because you're an employer here and you're overseeing people's lives in this setting. So you could, let's suppose, again, political affiliation is not in Title VII, but we're giving it a protection. So you could remove the term for the purposes of this policy legally and just have protected classification.
Right, and that's really not what I was asking, because the complaint procedures specifically says that if you believe you're being discriminated against on the basis of legally protected classifications, we're providing a, quote, protection or a right, as you just indicated above, for those outside of legally protected classifications, but our complaint procedures start out with if it's a legally protected classification,
well, I'm saying that one way to resolve that, and I think it meets everything, so that you're not then, for example, we have in other cases that we honor military status. In Florida, for example, and they're in FS 760, which is the civil rights statute, which is the mirror image of Title VII. There is marital status, but it's not in Title VII, so the state made it larger. And so, you know, they're all not in alignment, as you can see, and often the federal courts are called to bear to give the law its meaning. And all I was suggesting to you, if everybody recognizes there's no actual term called ethnicity, but everybody knows her ancestry, but everybody knows that is equivalent to national origin, but it's stated in a different way because EEOC develops a whole range of categories it wishes to sweep in all of those matters. So you can call it, they are legally protected because the courts are protecting them. But if it's a term that's not comfortable for the board as a policy matter, you can simply say on the basis of his or her protected classification, because you're protecting them. You're saying, well, thou shalt not in this district.